Here we are. So welcome everybody. Today we're going to, and we've done this one before, but it's a good refresher, is the whole use of multiple wills and using multiple wills with eState and how the drafts get created and what's in the drafts and those kinds of things. So why don't we start with that? So of course, the use of multiple wills is mostly in Ontario, some other jurisdictions. Some jurisdictions don't use them regularly. And the whole idea is to reduce the amount of probate tax on certain assets, those being assets that don't require probate in order to deal with them. The one that immediately comes to mind is sort of like personal effects, right? Nobody's going to require probate for you to transfer the sofa. So why pay probate tax on those? Why have to report those to the minister? So that's the whole sort of idea. The other big one that we typically see is private company shares, because our Business Corporations Act doesn't require probate to transfer shares. And as long as the board is okay with it, the board of directors of the corporation, then you can do that. So that's the big, those are the ones that we're trying to typically avoid probate tax on, among others. So let's take James Jones here, and let's just look at his assets, because it's going to be typically the assets that are going to direct us to consider multiple wills. So in this case, he owns private company shares worth $1 million, and probate tax on that would be about 15 grand. And he owns personal effects. We haven't put a value down for that. Some of the assets, for example, are owned by a trust, a bare trust here. And that's another category of assets that can avoid probate tax. The classic one is where you put a one kid on as a joint owner for the home, let's say. And the idea is that they're not really the joint owner, they're really holding it on trust, a resulting trust for the deceased, for the testator while they're alive and the deceased after their death. And although the property can be transferred automatically to the joint owner by right of survivorship, they're really holding it as part of the estate. And without a secondary will, you'd be required to pay probate tax on that. With a secondary will, you wouldn't. So that's another kind of asset that requires it, or can be used to avoid probate tax. So here we have a whole bunch of probate tax, $149,000, based on a whole bunch of different assets. So we'd fill that in with the client, and as we start going through the plan, we would have sort of a typical plan, and we could show them that right now there's $111,000 of probate tax. Why not 149? Well, because a bunch of assets are jointly held and are going to the surviving spouse. But we can show the client, so what would the impact of using multiple wills be? And we could just click here, and we would show them that if you use multiple wills, you're going to save, about 100 grand in $95,000 in probate tax by using multiple wills. What is in that calculation? Well, what are we excluding? We're excluding personal effects, so probate tax on personal effects, probate tax on private company shares, probate tax on shareholder loans, probate tax on assets that are held with a bare trustee. So that's sort of the, that's what's going into this calculation, that's showing the savings of $133,000 to the client. So it's even more dramatic, of course, if the spouse is not alive. Why? Because there's $149,000 of probate tax because there are no joint assets or designated assets in this scenario. But if we apply it, we can see that there's $94,000 of probate tax saved if we use multiple wills. And again, that's savings on those assets that I've identified. So you can easily demonstrate to the client, do you want to do it or not? And whatever extra you charge for multiple wills, for me, I typically charge $1,000 more for multiple wills. And if that's the case, then I can say, okay, it's going to cost you $1,000, but you're going to save, you may save if they don't change the legislation, and you don't own if you own these assets when you die, and all of those other things that we advise our clients on when deciding to make multiple wills. But as with the snapshot, you'd save $94,000. So that's sort of on the planning side, how you show that. I've got a question here, which I'm just going to see. How you designate the assets in estate. So just to show you, if I go to the surviving spouse scenario, all you do to designate, for example, if we were starting from scratch, the home was joint, so we would just drag the home over there. The RSP, we want to show that as designated to the spouse. We just drag that. You know, the TFSA, the life insurance, anything that's either joint or where there's designated as beneficiary, that's how you would show it. And the effect of that is it reduces the probate tax. So we can talk more about sort of when to use multiple wills, but let's go forward a little bit and say, okay, the client has now decided to generate or to hire you to do multiple wills. So the first thing I would do then is I'd say, great. And then the client would, you know, leave, let's say, and now I'm ready to draft. So remember in the provisions tab that there's a section for definitions of secondary will assets. So if you go to provisions, you'll see secondary will assets, and then you'll see a bunch of things. Some will be by default checked off. These are the assets that are going to be defined in the wills and included in the secondary will. Okay. And I'll take you through why the way we draft the secondary will and things like that. So, so in this case, you can pick which assets you want defined and included in the secondary will. I typically want my personal effects, specifically named corporations. So if I had any corporations, I'd want them specifically referred to. And then we have a basket clause, and I'll show you that right now, actually. So this is a secondary will, and there's a section for corporate assets. So corporate assets, this definition refers back to this, okay? Unspecified corporate assets are right here. So we've said, okay, corporate assets means the name. These are the specifically named corporations, so that's fine. And this is unspecified. So this is a basket clause that we typically include that says any other private corporation, business or enterprise that and then you have a choice. Do you want it to be just I control, or I or my spouse or my family control? And those would be included in the definition of corporate assets, which would be in the secondary will. Why do we talk about control? Well, think about this. If we just said any private corporation that I have shares in, but I didn't control, you might have a client who owns one share in a private corporation that has, 20 shareholders. Well, they're unlikely to be able to control the board and be able to ensure that those shares can be transferred without probate. So that's what we don't want to include a private company share that shares in a private company that we don't control, because it may be that it won't be able to avoid probate. And that's why we use this. And it's pretty typical drafting to use that kind of language. You don't have to, but that's how our language is generally drafted. So that's what's corresponding here. If I clicked controlled by all three, it would say that I or my spouse or my family control. Okay. Registry system real estate. So let me just show you where that corresponds. That's right here. And that's real estate that's either in the registry system still, very unlikely, or where it's been converted to the land titles, and this would be a first dealing. So typically I always include that, even though it might be very unlikely that they'll ever own it. I once had a case where that was they did own it, and I should have put it in. And so I always pretty much include that one. Trust assets. What do we mean by trust assets? So these are assets that are being held on resulting trust, as well as any other. So it means any assets which are held in trust for me or my benefit, or the benefit of my estate at the date of death. So those assets that are held by a bare trustee or on a resulting trust. And then we have trust loans, non-arm's length loans. I'll just show you a couple of these. These are all, so trust loans mean any amount owing to me from any trust. Non-arm's length loans means any loans that are owing to me, loans that are owing to me by my spouse or by any of my children. That's this sort of the non-arm's length loans. You could always change the definition if you wanted to be something different if you wanted it. Partnership interests, other life insurance. That's a policy of life insurance which you own, so the testator owns it, but it's payable on the death of some other person. And I think that was it. Partnership interests are there. So you get to pick when you're in the portal which ones you want to include in the definitions. You might want to just say as a default, just include all of them. And if they don't own those, they don't own them. And that's fine too. Because that's how a will works. I mean, if you're talking about partnership interests, you know, it says any partnership interests I own on my death is governed. Well, if you don't own any, you don't own any. That's not a big deal. So those are the definitions of assets. Our drafting in the estate multiple wills includes this idea of disclaimed assets. So if we put an asset that would normally be caught by this definition, any of these definitions, so, you know, it is registry system real estate, for example, and for whatever reason, we can't deal with that property because you need probate, okay? Another example is personal effects, which would normally be in the secondary will, but it's a very expensive painting. And when you go to sell it, they want probate. What this allows you to do is disclaim the asset from the secondary estate. And so it falls into the primary estate. And I'll show you that paragraph right here. So it's a clause from Milne that was basically adopted or agreed to by the Court of Appeal that said that, you know, you can disclaim entitlement that would otherwise form part of my secondary estate if the trustees determine that a grant of authority, of probate, is required for the transfer. And that's a similar language to Milne that was accepted by the Court of Appeal. So that's how we deal with that. So we'll get to some of the other questions about multiple wills in a moment. So just if you've posted a question, I haven't gone to it yet. That's why, because I'm going to deal with those all at once. And then we define what's in each of the wills. So I typically take my clients through the secondary estate first. And I say, okay, your secondary will is going to govern your personal effects, your digital assets, the corporate assets, your trust assets, your registry system real estate, your trust loans. And again, this is going to populate whatever you've checked off here is going to populate in the definition here. Okay. And it then ends with provided that they are not disclaimed assets. Okay. And then of course your primary estate deals with everything except those, but includes disclaimed assets. Okay. So that's how the definitions are generated through the portal, and then how they appear in the primary and secondary wills. And of course, the definitions are in both wills. So questions before we get to provisions that are in the secondary will that are unique. So private corporations controlled by, doesn't that force assets for probate even if the estate can get on board to transfer without probate? Yes, it would. So if it's a private corporation that that doesn't need probate, you would do that. So one of the things you might want to do, which I always do, is in my reporting letter, I mean, I don't want to use a basket clause that would be broad enough to capture a bunch of assets that I think would cause some issues. So what I prefer is to suggest to my client that they advise me of any other private corporations that they acquire, and then refer to them specifically if I'm satisfied that they can they can do it without probate. Now you might say, well, go with a broader definition and then just disclaim it, which is a fair argument. We've decided not to do it that way, but you could certainly change that, or in the draft if you wanted to. You would just take out controlled by. You could just say owned by. So a life insurance trust, I'll explain how that might work in a moment. Any issues with using the simple will template for primary? Yeah, I would not use the simplified provisions. So let me just show you. So now we filled this out and we want to create multiple wills. So let me just do that. So I go to the download button, documents, multiple wills. That's the one I choose. You can put it, it's basically the same as a single will. I typically would never include simplified provisions. If I'm doing multiple wills, this thing is going to be long. I want it to be long. I want to have every provision in there. There's probably a business involved, and I'm not going to pick simplified provisions for multiple wills. We give you that option. I wouldn't recommend it. Okay. So that would be how you generate the multiple wills, and when to use primary and secondary as simplified provisions. So the difference between the primary will and the secondary will. So yes, it's going to be a slightly different will than the simplified wills, the single wills. It's going to refer to, primary estate and things like that. It's going to have provisions about allocating debts between the different wills. I would caution you that about using, different dispositions under different wills. A different residue clause, for example, or a different a set of executors or anything like that. Be very careful. eState does not contemplate you doing that. And if you want to do that, go ahead, but that wouldn't be what I would recommend and what eState is set up to do. So the way it works is the initial gifts, any specific legacies of money are referred to in the primary will, okay? And then, maybe I'll just show you, I did a compare here. Let me just show you what the difference between the primary will and the secondary will is. That might be an easier way to show it to you. So of course it changes the reference to primary and secondary will. The funds and plans provision, the designation of beneficiaries is in the primary will document, although it's not part of the primary estate, of course, it's separate. Obviously you can see where it defines different things. I just want to show you, these are going to be identical in both wills. There is one thing I want to show you, this clause. So this clause says, because we've got a specific amount to be paid from the residue, we have this idea that you didn't see this, but the trust is set up and they get $250,000 at age 25. We don't want that paid at twice, once out of the primary estate, once out of the secondary estate. So we have this, that any reference to a specific sum of money, regardless of whether it's paid only once, right? That's the idea. And it should be adjusted as well. So that's a clause that's in there. Then it's got, in the secondary will, it's got the disclaimer provisions. So anything that you see that's highlighted and underlined is in the secondary will and not in the primary will. The primary will contains the RESP provision. The personal effects, though, are in the secondary will. So you'll see some things are out, some things are in. And the initial gifts, as I said before, those appear in the primary will. In the secondary will, what it says is that if any of the gifts in my primary will, specific amounts are not paid because of abatement, okay, not because of some other reason, but because there is not enough money in the primary will, then I want you to satisfy it to the extent that you haven't satisfied it under the primary will, satisfy it under the secondary will. That's how we do it. And then the residue clause should look identical in both wills. Any specific amounts, this is in the ultimate distribution, any specific amount there is not going to be referred to twice. It's going to just refer to the amount set out in the primary will. Basically, the other provisions are there. The double legacies, that's where, remember, the two spouses each have the same legacy. We don't want to pay twice if they die within 30 days of one another. So that only appears in the primary will because we don't repeat the legacies in the secondary will. And that's why we use the term only because of abatement. We don't want it paid twice under any circumstance. And then basically the provisions are pretty much identical. We don't have the guardianship clause in the secondary will. So that's how that works. And yes, so that's what I wanted to talk about. Anybody have questions about things that I've raised directly first, and then you can then we can talk about other questions. So feel free if you'd like to raise any questions. And I'll address the life insurance in a moment. Anybody have questions about the way it's drafted? Oh, there is one thing I wanted to show you. The way, and people ask us, so a couple things before we move on. The first thing is this idea of under the executors, we put this in both wills, and I'll tell you why. This additional provisions that the trustee has no obligation to obtain letters probate. So the reason we put that in is, and that's in both wills, it's more likely that they won't get probate on the secondary will, but it's also possible that they won't get probate on the primary will because for whatever reason they can avoid probate for the entire primary will, and this just protects them from getting probate in the primary will in case. So that's why that's in both. The other thing is any specific gift, and I don't know here, let me just show you how this would generate, because I don't think I did a specific gift in this, but let's just give a specific asset to, I don't know, to the kids, I don't know, children. So here we have a gift of a specific asset in initial gifts, right? So now let's generate the multiple wills, and I'll show you, we can keep all these things in there, that's fine. I'll just show you how it gets drafted with specific assets, because the gift of the specific asset will appear in both wills. And it'll say, to the extent that the house or the home falls into my primary estate, give it to John. To the extent it falls into my secondary estate, give it to John, and that would appear in the secondary will. Why do we do that? Well, you know, here's why we do it. It's possible that the home, we don't know what will it's going to be in, what estate it's going to be in. Is it, you know, you could say, well, it's going to be, of course, it's going to be in the primary will because it's a condo, right? And a condo requires probate, and so why put it again? Well. Here's why. Because if it's held on a resulting trust, they put a kid's name on it jointly, then it's going to fall into the definition of trust assets and be able to be dealt with under the secondary will. So that's why. We don't know what assets are going to be in, and vice versa. You might have an asset you think, oh, it's for sure going to be in the secondary will because it's private company shares. But what happens is by the time they die, they've made it, it's a public company, or it's a company that's widely held and you need probate or whatever reason. Now you disclaim it. Now it's part of the primary estate. So now it says with respect to whatever the property was, and to the extent that it forms part of my primary estate. And then when we go down to the secondary will, you'll see the same clause in the secondary will. And it'll say to the extent it forms part of my secondary estate. Okay, so that's how we do it. Now, the other thing that I want to show is the idea of an insurance trust. So here we've got sort of the classic, we made we're designating the spouse as the beneficiary of the life insurance if she's alive, but if she's not alive, we don't do any other designation. But we want to do an insurance declaration to avoid the probate tax. So let me just do that, and I'll show you how that differs in the primary and the secondary. So you'll want that to be dealt with. It's going to refer to dealing with the proceeds in the same manner as the residue of my estate. So here's what the legacy says. It says, or the life insurance designation, my spouse is alive, pay it to her. My spouse is not alive, pay it to the other executor as the trustee of that, to be dealt with as a separate insurance trust to administer it in the same manner and on the same terms as I've provided for the residue of my estate as set out in my secondary will. So I just typically like the idea of having it dealt with in the same way as my secondary will. Probably it doesn't matter. You could say it the same as my primary will, but I prefer to use it as a secondary will, which should be identical. At least if you use eState, it's going to be identical. So hope that helps on that front. Do you include U.S. assets, real estate in the secondary wills? No. And the reason being, well, first of all, U.S. assets, real estate, we know is you're not going to pay probate tax on. So it doesn't matter that it's in the primary will. And you may want to get an ancillary grant. So they're going to probably need probate down in the States, and they may take your probate and get an ancillary grant in the US. So you want actually a probated will that governs that asset. So that's why I would not put that in the secondary will. Other US assets will also probably require probate. And so if they require an ancillary grant, you probably want it under the primary will. You will attract probate tax, but there's probate tax. You know, because I'm not sure you can get away with them without probate with a secondary will in the US, unless you're willing to give advice on that. And yeah, I wouldn't be prepared to do that. So jointly as creditors for private debts that are not registered, would you use a separate will for those? Not for debts. Oh, they're creditors for private debts. Yeah, so I mean, if you think you can collect the debt without probate. So here's the problem about, it's really, I guess in essence, what the asset is a loan. So you're here and you've got a loan that's outstanding from somebody. And so you've got, in this case, you've lent money to somebody. So let's just show you how that's a loan receivable, and it's a third party. So for, $200,000, and you could make it joint, that's fine. Just talking about the idea of multiple wills, assume that you have to sue for that $200,000 and it's governed by the secondary will. The problem with that is that you can't sue without probate. And so query whether you'd have to disclaim that asset or do something in order to do that. So it's just an issue there. How do you deal with more than one life insurance? Well, if you have a bunch of life insurance, when you click the life insurance designation, it's going to create separate documents for each one. Okay, and it'll identify the the policy number and all of that. So other questions? We're almost at 1, and typically like to finish at least the formal part of the presentation by 1. And I don't know if everybody is unmuted, or I'm going to unmute everybody and just see if anybody has any questions. The great thing, of course, with eState is a client can say, well, let's do single wills, and then you change it and you want to do multiple wills. All you do is you regenerate the document, and you can charge. I would say to you that you should be charging more for multiple wills than single wills. But it shouldn't take you much longer to generate a secondary will at all. Right? There are all kinds of things to think about when you make secondary wills and multiple wills. Most of them have been considered by eState, and we've built those into the drafting. So you're not replacing, not referring to legacies twice. You're not, and we try to cover off on those things, but multiple wills do create some issues, so you have to always be careful about them. Other questions about multiple wills?
Jordy, it's Kit
Yeah,
Bennett. With respect to the insurance,
yes.
if all of the policies are issued by the same life insurance company,
Yes.
and are going to receive identical treatment,
Yes.
you can get away with covering it under a single declaration.
Right.
The flip side, if you've got multiple policies, different insurance companies, it's better from a policy administration perspective to have separate declarations. The other element is if you've got multiple policies, even though they're with the same company, you might want different beneficiaries.
Right. We do that. And
Yeah.
so
And I like the way eState does the separate declarations,
that's what
because
I was
that
going to say.
forces us to go through the logic, the logic flow that I just went through.
Yes.
Right.
And I prefer setting separate designations. You keep track of them too, as well. Like just to demonstrate, I'm glad you agree. I was terrified, Kit, that you were going to say this is separate ones are a terrible way to go. Oh boy.
No. I'm all in favor of efficiency when it works.
Yeah. Well, this is pretty efficient in the sense that they're generated automatically. But here you'll see there's two separate designations. And yeah, I just like to keep them separate. And yes, it requires them signing another piece of paper. But if one gets eliminated and then you just don't have any questions about how you interpret it, if it refers to multiple policies, things like that. So that's why
I will, Jordy, on one where I confess, because I'm a completist, okay?
Yes.
Jordy knows this. My view on insurance trusts, and this is just because I've worked in the insurance industry and seen some of the things that can go wrong. I prefer to not use the mutatis mutandis provision or refer to dealing with the insurance as if it were similar, same as the residue, because the question, and because I dealt with a file where this came up, they'd actually changed their will. So they'd done the insurance trust in a separate document.
Right.
Okay. They changed the will. So now what you had was an insurance trust document that was referring to this will that had been revoked, and they didn't get around to changing the insurance. And it was, I think the technical term was a bollocksed up mess.
Yeah. Well, that's, yeah, but I think
so, kill a shrub. And
that is an issue, but quite frankly, that's because the lawyer who changed the will didn't probably do a good job in canvassing assets.
Absolutely. The new wills were done by a different lawyer.
Right.
But from a backup perspective, because I don't think I don't ever want to, I would not advocate that anyone ever have to write an E&O check, for your deductible. I think it happens, and comprehensive fact finding is wonderful, but it doesn't happen in all cases. So that's just one that may be in your reporting letter if you use this approach, which is it's efficient.
Right.
Make sure to remind the client that if they change their will, they should update their designation.
Yeah, and the downside to putting it right in the will,
I don't like that at all.
The provisions is that you didn't change that either, and so now that doesn't reflect what they wanted to do in the new will. So I think either solution causes problems, but yeah, I take your point. It's important it's important though to cover that off one way or the other in the reporting letter for sure.
Yeah. So but as I said, I particularly like the separate declaration formatting because it requires us to think about what are we doing.
Right. And again, another good reason, the number one cause of claims against the state lawyers is inadequate investigation. There's a classic one, right? The lawyer didn't do proper investigation of assets, and that's how we get in trouble.
Jordy, and this is just again, because I deal with a life insurance company that issues a lot of critical illness insurance policies on the lives of children, which are very often owned by the parents.
Right.
So you might consider down the road living benefits insurance on other lives,
Yep.
because that
will hear.
again potentially becomes a secondary will, becomes an issue from a planning perspective.
Right. Again, the question becomes, how much is that policy worth at the time of death of the,
When it's a
the
20 pay that's fully paid up, there's a potential refund of premium, depending on the amount of the premium, that could be multiple thousands, tens of thousands of dollars.
right. And again, for me, and that's
Yeah.
fine. I mean,
Yeah.
fair enough. And but that goes into the calculation of whether we need it. And that's good. That's good. Thanks. No, Kit always has great ideas on insurance, because she knows it better than pretty much anybody in the country. So thanks, Kit, for that.